I never imagined that a 20-inch snowfall in February would turn into a legal nightmare that would consume 6 months of my life. But that's exactly what happened when the Ridgeview Heights HOA decided to go to war over a driveway. My name is Nathan Ellison, and I bought my house in Ridgeview Heights, a subdivision in Boulder, Colorado, back in 2023. The neighborhood was decent enough, nothing fancy, just cookie-cutter houses built in the early 2000s with decent mountain views. When I moved in, the HOA seemed relatively hands-off. I paid my dues, kept my lawn maintained, and generally stayed out of trouble. I worked from home as a software developer, which meant I spent most of my time inside anyway, barely interacting with my neighbors except for the occasional wave. The trouble started on February 12th, when Colorado got hit with one of those massive winter storms that shut down half the Front Range. I woke up that Tuesday morning to find my driveway buried under nearly 2 feet of fresh powder. The storm had come through overnight, and the plows hadn't even made it to our neighborhood yet. I had a video call with a client at noon that I absolutely could not miss, so I did what any reasonable person would do. I called a local plowing service. The company I hired, Mountain View Snow Removal, sent a guy out within 2 hours. He plowed my driveway, did a decent job of it, charged me $140, and that was that. Or so I thought. I made my meeting, got my work done, and didn't think twice about the snow removal. It seemed like the most mundane, forgettable transaction imaginable. 3 weeks later, I found an envelope in my mailbox from the Ridgeview Heights HOA. Inside was an invoice for $350 labeled as unauthorized snow removal services. I read the letter 3 times, convinced I was missing something. According to the invoice, I had violated Section 12.4 of the HOA covenants by hiring an outside contractor to perform maintenance services without prior approval. The letter was signed by Patricia Winters, the HOA president, in neat, aggressive handwriting. I immediately pulled out my copy of the HOA covenants and conditions, a document I had admittedly only skimmed when buying the house. I flipped through the dense legalese until I found Section 12.4. It read, "Homeowners must obtain prior written approval from the Board of Directors before contracting any exterior maintenance services that may impact common areas or the aesthetic uniformity of the community." I sat there staring at the page, trying to figure out how plowing my own driveway could possibly fall under this rule. My driveway was entirely on my property. It didn't touch any common areas. The plow driver hadn't gone anywhere near the street or the sidewalk, both of which the city was responsible for anyway. This made absolutely no sense. I decided to handle it like a reasonable adult. I called the number listed on the invoice and got Patricia's voicemail. I left a polite message explaining that I believed there had been a misunderstanding, that my driveway was private property, and that I would like to discuss the matter. I asked her to call me back at her convenience. She called back the next day at 8 in the morning, right when I was in the middle of debugging some particularly frustrating code. I answered the phone with what I thought was a neutral, professional tone. "Mr. Ellison, this is Patricia Winters from the HOA board. I received your message." Her voice had that particular quality of forced patience that immediately put me on edge. It was the voice of someone who had already decided they were right and was simply going through the motions of appearing reasonable. "Thanks for calling back," I said. "I wanted to talk about this invoice I received. I'm confused about why I'm being charged for plowing my own driveway." "The covenant is very clear, Mr. Ellison. Any exterior maintenance requires approval. You hired an outside contractor without consulting the board. That's a direct violation. But it's my driveway. It's on my property. I needed to get out for work. That's not the point. The covenant exists to maintain standards and uniformity. If everyone just hired random contractors whenever they wanted, we'd have chaos. Different quality levels, different aesthetics, different equipment tearing up our roads. The plow never touched the road, I said, trying to keep my voice level. It was completely confined to my property. Nevertheless, the rule was violated. The board has discussed this, and we're unanimous in our position. The fee stands. You have 30 days to pay. What is this fee even for? I already paid the plow driver. It's an administrative fee and a penalty for the violation. It's all outlined in the enforcement provisions of the covenant. I took a deep breath. Patricia, with all due respect, I think this is unreasonable. I'd like to appeal this to the board. I am the board president, Mr. Ellison, and the board has already made its decision. The invoice is final. If you don't pay within 30 days, we'll add late fees and potentially file a lien against your property. She hung up before I could respond. I sat there holding my phone, stunned at how quickly a simple conversation had turned hostile. I spent the rest of the day alternating between work and researching HOA law in Colorado. What I found was both encouraging and disturbing. Colorado had specific statutes governing HOAs, including provisions about how they could enforce covenants and what rights homeowners had. But I also found countless horror stories about HOAs taking people to court over the most trivial matters imaginable. That evening, I drafted a formal letter to the HOA board requesting a hearing. Colorado law required HOAs to provide homeowners with an opportunity to be heard before imposing fines or penalties. I kept the letter professional and factual, outlining my position that plowing my private driveway did not fall under Section 12.4, and that even if it did, the penalty was disproportionate and unreasonable. I sent the letter via certified mail the next day. 2 weeks passed with no response. Then, on a Thursday afternoon, I came home from a grocery run to find another envelope from the HOA. This one contained a notice of a board meeting scheduled for the following Tuesday at 7 in the evening. The notice was terse and formal, stating only that my appeal would be heard and that I should be prepared to present my case. The meeting was held in the community clubhouse, a bland rectangular building near the neighborhood entrance that mostly got used for book clubs and yoga classes. I arrived 10 minutes early with a folder containing copies of my deed, the relevant HOA covenants, photos of my driveway, and printouts of Colorado HOA statutes. I was nervous, but felt prepared. The board consisted of 5 people sitting behind a folding table at the front of the room. Patricia was in the center, a woman in her mid-50s with short blonde hair and a rigid posture. To her right was a heavy-set man who introduced himself as Dale, the vice president. To her left were 3 other residents whose names I immediately forgot. About a dozen other homeowners sat in the scattered chairs around the room, apparently there to watch the proceedings. Patricia called the meeting to order with a sharp rap of her knuckles on the table. She went through some routine business about landscaping contracts and pool maintenance, speaking in a clipped, efficient manner that made it clear she ran these meetings like a corporate board. Finally, she turned her attention to me. Next item. The appeal of Nathan Ellison regarding the snow removal violation. Mr. Ellison, you have 5 minutes to present your case. I stood up, suddenly very aware of all the eyes on me. Thank you. I'm appealing the $350 fine for hiring a snow plow service in February. My position is straightforward. The work was done entirely on my private property. Section 12.4 of the covenant refers to maintenance that impacts common areas or community aesthetics. Plowing my driveway does neither. The plow driver never touched common property, never damaged anything, and the work was necessary for me to access my home and conduct my business. Patricia's expression didn't change. Are you finished? I'd also note that the fee seems excessive for what amounts to a paperwork issue, assuming there even was a violation, which I don't believe there was. The board will now deliberate. I expected them to at least ask me some questions or discuss the matter. Instead, Patricia and the other board members leaned in for a whispered conversation that lasted maybe 30 seconds. Then she straightened up and looked directly at me. The board has considered your appeal and finds it without merit. The covenant is clear, and your violation is documented. The fine stands. You now have 15 days remaining to pay. If payment is not received, we will add a late fee of $50 per week and begin lien proceedings. This matter is closed. You can't be serious, I said, my voice rising despite my best efforts. You didn't even consider what I said. We considered it and rejected it. The decision is final. Do you have anything else to add? This is ridiculous. You're fining me for maintaining my own property. If you wish to challenge the board's decision, you're welcome to pursue legal action. Now, we have other business to attend to. Please sit down or leave. I felt heat rising in my face. Every instinct told me to keep arguing, to make them see how absurd this was. But I could see in Patricia's eyes that there was no point. She had made up her mind before I even walked in the door. This whole hearing had been a formality, a box to check so she could say she'd given me due process. I gathered my papers and walked out. Over the next few days, I tried to let it go. $350 was annoying but not devastating. Part of me just wanted to pay it and move on with my life. But every time I considered doing that, I'd get angry all over again. It was the principle of the thing. Patricia was abusing her power, making up violations to justify fines, and treating homeowners like subjects rather than neighbors. I talked it over with my girlfriend, Grace Kimball, who I'd been dating for about a year. She was a high school math teacher with a much more diplomatic personality than mine. We were having dinner at her apartment when I laid out the whole situation. I don't know what to do, I said, pushing pasta around my plate. Part of me wants to fight this on principle, but the other part thinks I'm being stubborn and should just pay it. Grace considered this while taking a sip of wine. What happens if you don't pay? They add late fees and eventually put a lien on my house, which could affect my credit, my ability to refinance, all kinds of things. And what happens if you do pay? Then Patricia wins. And she'll probably pull this same garbage on someone else, or come after me again for some other made-up violation. So you're really asking whether you want to take a stand or take the path of least resistance? I guess so. She reached across the table and squeezed my hand. I can't tell you what to do, but I know you, Nathan. You're going to be angry about this for months if you just roll over, and $350 now might turn into thousands later if she keeps pushing. She was right, of course. I'd been leaning toward fighting it, but hearing Grace validate that instinct made the decision feel less crazy. The next morning, I started looking for lawyers. I found a firm in Boulder that specialized in HOA disputes. The attorney I spoke with, a woman named Jennifer Martinez, listened to my story and asked to see all my documentation. I scanned everything and emailed it over. She called me back 2 days later. Mr. Ellison, I've reviewed your case, and I think you have a strong argument. The covenant language is ambiguous at best, and Colorado law requires HOA rules to be reasonable and uniformly enforced. A $350 fine for plowing your own driveway seems excessive on its face. So you think I can win? I think you have a good shot. But I need to be upfront about costs. My retainer is $2,000, and this kind of case typically runs between $3,000 and $5,000 in legal fees if it goes to court. It might settle before that, but you need to be prepared for the possibility of spending more on lawyers than the actual fine. I winced. That seems insane. It is insane. That's how HOAs often win these disputes. They count on homeowners deciding it's not worth the legal fees. But Colorado does have a provision where if you prevail, you can ask the court to award attorney fees against the HOA. It's not guaranteed, but it's possible. I thought about it for maybe 10 seconds. Let's do it. Jennifer drafted a response to the HOA on my behalf, laying out our legal position and demanding they rescind the fine. She sent it via certified mail with a CC to every board member. The letter was professional but firm, citing specific Colorado statutes and case law about HOA enforcement. The HOA's response came a week later. It was a one-page letter from Patricia stating that the board stood by its decision and considered the matter closed. But attached to that letter was something I didn't expect: a formal complaint for debt collection filed in Boulder County Small Claims Court. The HOA was suing me for the original $350 plus $200 in late fees and administrative costs. They're doubling down, Jennifer said when I forwarded her the complaint. This is actually good for us. It means we get to present our case to a judge instead of just arguing with the board. Small claims in Colorado allows for attorney representation, and the discovery process is streamlined. We can get this resolved relatively quickly. The court date was set for 6 weeks out in late April. Jennifer got to work immediately, filing our response and a counterclaim for attorney fees under Colorado's wrongful collection statute. She also submitted requests for the HOA to produce all their records related to Section 12.4 enforcement, including any instances where they had or hadn't fined other homeowners for similar issues. The discovery process turned out to be illuminating. The HOA's records were a mess. They had no written policy defining what exterior maintenance meant under Section 12.4. They had no history of fining anyone else for hiring contractors, even though Jennifer found evidence of at least a dozen homeowners who had hired landscaping services, painters, and roofers without seeking board approval. In fact, Dale, the board vice president, had hired a tree removal service just 3 months before my snow plowing incident, and there was no record of him seeking approval or being fined. This is selective enforcement, Jennifer explained during one of our prep sessions. The covenant has to be applied consistently. If they're not fining other people for the same behavior, they can't single you out. That's discrimination, and it violates Colorado's fair housing and HOA statutes. So, why did they come after me specifically? That's a good question. Do you have any history with Patricia or the board? I thought back. Not really. I've been pretty low-key, although. What? There was this thing last summer. The HOA wanted to increase dues by 20% to renovate the clubhouse. There was a homeowner meeting to vote on it. I voted against it and spoke up about how the clubhouse was fine and the money would be better spent on actual maintenance issues. Patricia got pretty defensive. Jennifer nodded. That could be it. Some HOA board members treat any pushback as a personal attack. She might have been looking for an excuse to assert authority over you. As the court date approached, I found myself oscillating between confidence and anxiety. Jennifer seemed certain we had a strong case, but I'd heard enough stories about small claims court being unpredictable. Judges had broad discretion, and there was no guarantee they'd see things our way. The night before the hearing, I barely slept. Grace came over and tried to distract me with a movie, but I couldn't focus. I kept running through the arguments in my head, imagining different scenarios. "You're going to be fine," Grace said, pausing the movie and turning to face me. "You've got a good lawyer, you've got the facts on your side, and honestly, what they're doing is ridiculous. Any reasonable judge will see that. I hope you're right." "I am right. And even if somehow things go sideways, it's not the end of the world. You'll pay the fine and move on, but I really don't think it's going to come to that." The hearing was scheduled for 9 in the morning at the Boulder County Justice Center. I met Jennifer in the lobby at 8:30, wearing a suit I'd bought specifically for the occasion. She was carrying a leather briefcase that looked like it had been through a few wars. "Ready?" she asked. "As I'll ever be." We went through security and made our way to the courtroom. It was smaller than I expected, with maybe 20 seats for spectators and a simple bench for the judge. Patricia was already there with a man I didn't recognize, presumably her lawyer. She was wearing a navy pantsuit and had her hair pulled back in a tight bun. She glanced at me once when I walked in, her expression cold and dismissive. At exactly 9 o'clock, the bailiff called the court to order, and Judge Timothy Brennan entered. He was an older man, probably in his late 60s, with gray hair and wire-rimmed glasses. He had the weathered look of someone who'd been dealing with people's problems for decades and had long since stopped being surprised by anything. "Good morning," Judge Brennan said, settling into his chair and opening a folder. "Case number 2024 SC-01847, Ridgeview Heights Homeowners Association versus Nathan Ellison. I've reviewed the filings from both parties. Let's start with the plaintiff. You're seeking $550 in fines and fees related to a snow removal violation. Is that correct?" Patricia's lawyer stood up. His name was Richard something, and he had the polished look of someone who spent most of his time doing much bigger cases than HOA disputes. "That's correct, Your Honor. Mr. Ellison violated the clear terms of the community covenants by hiring an outside contractor without board approval. The fee is both a penalty for the violation and reimbursement for administrative costs." "What administrative costs?" the judge asked, flipping through pages. "The board had to hold meetings to discuss the violation, send correspondence, and now appear in court. The homeowner has been repeatedly non-compliant. Mr. Ellison is here with counsel, which suggests he takes this seriously. Let's hear from the defense." Jennifer stood smoothly. "Your Honor, this case is fundamentally about whether the HOA can fine a homeowner for maintaining his own private property. The covenant section in question refers to maintenance affecting common areas or community aesthetics. Plowing a driveway during a snowstorm does neither. Moreover, we've discovered through the legal discovery process that the HOA has never fined anyone else for similar conduct, including a board member who hired contractors without approval. This is selective enforcement, which Colorado law prohibits." Judge Brennan looked at Patricia's lawyer. "Do you have any evidence of similar enforcement actions?" Richard shuffled through his papers. "Your Honor, each situation is evaluated on its own merits. The board has discretion in how it enforces the covenants. Discretion doesn't mean arbitrary action." "Do you have any written policy defining what requires approval? The covenant itself is the policy." "Have you fined other homeowners for hiring contractors?" "I'd have to review the records to answer that specifically." "You're the plaintiff. You should have reviewed the records before filing suit." Judge Brennan turned to Jennifer. "Counsel, you mentioned evidence of inconsistent enforcement." Jennifer handed a stack of documents to the bailiff, who passed them to the judge. Your Honor, these are records we obtained through discovery. They show at least 15 instances in the past 2 years where homeowners hired outside contractors for various services including landscaping, roofing, painting, and tree removal. None of them sought board approval, and none were fined. One of those homeowners is Dale Ferguson, the board's vice president. The judge studied the documents for several minutes. The courtroom was silent except for the rustle of papers. I could feel my heart pounding. Finally, Judge Brennan looked up. "Mr. Richard, your client's selective enforcement here is troubling, but let's go back to the underlying question. Do you seriously contend that a homeowner needs HOA approval to plow his own driveway during a snowstorm? The covenant requires approval for exterior maintenance, Your Honor." That's the plain language. The language says maintenance that impacts common areas or aesthetics. How does plowing a driveway meet that standard? Any exterior work potentially impacts aesthetics. That's absurdly broad. Under that interpretation, a homeowner would need approval to wash their car or water their lawn. Judge Brennan closed the folder and leaned back. "I've heard enough. The plaintiff's case is without merit. The covenant language does not reasonably extend to snow removal on private property, and even if it did, the selective enforcement makes this fine improper. Judgment for the defendant." I felt a wave of relief so powerful I almost laughed out loud. Jennifer put a hand on my arm, keeping me composed. "Furthermore," the judge continued, "I'm awarding attorney fees to the defendant under Colorado Revised Statutes Section 3833.3 The plaintiff's action was unreasonable and brought in bad faith. Counsel for the defendant, please submit an affidavit of fees within 14 days. Patricia's face had gone red. She leaned over and whispered something harsh to her lawyer, who shook his head. "Is there anything else?" Judge Brennan asked. Jennifer stood again. "Just one thing, Your Honor. We request that the court order the HOA to rescind any liens or negative reports to credit agencies related to this matter." "Granted. The HOA will remove any liens within 10 business days and provide written confirmation to Mr. Ellison. We're adjourned." The gavel came down, and it was over. We walked out of the courtroom into the bright Colorado morning. I felt like I was floating. Jennifer was smiling, which I'd learned was rare for her. "That went even better than I expected," she said. "Judge Brennan doesn't suffer fools, and he clearly thought the HOA's position was foolish. We'll get you reimbursed for my fees, and the HOA will have to cover their own lawyer too. This probably cost them $10,000 or more." "Good," I said. "Maybe they'll think twice before pulling this on someone else." I called Grace from the parking lot, and she squealed with excitement when I told her the news. We made plans to celebrate that evening. I spent the rest of the day feeling victorious and vindicated, but the story didn't end there. 2 weeks after the court hearing, Jennifer submitted her fee affidavit showing she had spent 32 hours on my case at a rate of $200 per hour, totaling $6,400. The court approved it without modification and ordered the HOA to pay within 30 days. Around that same time, I started hearing from other neighbors. Word had gotten around the development about the lawsuit, and suddenly people were telling me their own HOA horror stories. One couple had been fined for putting up Christmas decorations 1 day earlier than the approved date range. Another had received violation notices for having the wrong shade of white on their fence. A woman 3 doors down had been cited because her car was parked in her own driveway instead of the garage, supposedly violating some aesthetic rule nobody had heard of. The common thread in all these stories was Patricia. She was the driving force behind the enforcement actions, the one pushing for fines and penalties. Dale and the other board members apparently just went along with whatever she wanted. In early May, the HOA held their annual meeting to elect board members. Attendance was usually sparse, maybe 20 homeowners out of the 200 in the subdivision. This year, over 100 people showed up. I wasn't planning to go, but Grace convinced me I should. "You started something," she said. "People are finally paying attention to how the HOA operates. You should be there to see it through." The meeting was tense from the start. Patricia tried to run it with her usual iron fist, but people kept interrupting with questions and complaints. When it came time for board elections, someone nominated me to run against Patricia for president. I tried to decline, but the nomination was seconded and the vote was called before I could properly object. When the ballots were counted, I had won by a margin of 73 to 42. I was the new HOA president, a position I had absolutely no interest in holding. Patricia's reaction was icy. She gathered her papers, stood up, and walked out of the clubhouse without a word. Dale and one other board member followed her, leaving 2 remaining members and me to figure out what came next. Over the following weeks, I learned just how much of a disaster Patricia had created. The HOA's finances were a mess, with money being spent on legal fees and pet projects without proper authorization. She had routinely ignored homeowner complaints while pursuing petty violations. There were half a dozen ongoing disputes with residents that never should have escalated. My first act as president was to call a special board meeting to review all pending enforcement actions. We went through each one, and in almost every case, we found the violation was either bogus or wildly overpenalized. We rescinded the fines, apologized to the homeowners involved, and drafted a new enforcement policy that emphasized education and cooperation over punishment. The second thing I did was hire an accountant to audit the HOA's books. What she found was disturbing. Over the past 3 years, Patricia had approved payments totaling nearly $15,000 to various vendors for services that were either never performed or grossly overcharged. One landscaping consultation had cost the HOA $3,000, but there was no report or any evidence of work done. Another payment of $5,000 had gone to a lawyer for covenant review, which turned out to be a 2-page memo. Some of the charges might have been legitimate but poorly documented. Others looked suspiciously like fraud. The accountant recommended we contact the Colorado Attorney General's office. I agonized over that decision. Despite everything Patricia had put me through, I didn't relish the idea of potentially sending her to jail. But the money she'd wasted belonged to all the homeowners, and if there was actual fraud, it needed to be addressed. In the end, I brought the accountant's findings to the full board and let them vote on what to do. The decision was unanimous. We filed a complaint with the Attorney General and turned over all the financial records. The investigation took months. During that time, life in Ridgeview Heights slowly returned to a kind of normalcy. We focused on actual maintenance issues, held regular town halls to hear homeowner concerns, and tried to be reasonable about enforcement. People seemed happier. The neighborhood felt less like a police state and more like an actual community. Grace and I grew closer through all of this. She'd been my sounding board and support system through the lawsuit and the chaos of becoming HOA president. That summer, I asked her to move in with me. She said yes. In October, 7 months after Judge Brennan had thrown out the HOA's case, I got a call from an investigator with the Attorney General's office. He wanted to meet in person to discuss their findings. We met at a coffee shop in downtown Boulder. The investigator, whose name was Marcus Chen, was a serious young man with a no-nonsense demeanor. He laid out what they'd found. "We've identified approximately $23,000 in questionable payments over a 3-year period," Marcus said. "In about half of those cases, we can definitively prove the services were never rendered. Patricia Winters was approving these payments and in some cases creating fake invoices from shell companies. It's textbook embezzlement." I felt sick. How did she think she'd get away with it? Most people don't scrutinize HOA finances. She was counting on apathy. If you hadn't pushed back on that snow plowing fine, nobody would have looked closely at what she was doing. Your lawsuit created a spotlight. What happens now? We're filing criminal charges. Theft, forgery, abuse of fiduciary duty. She'll likely be offered a plea deal, but if she refuses, it goes to trial. Patricia was arrested 2 weeks later. It made the local news, a brief story about an HOA president accused of embezzling from her own neighborhood. The story mentioned my lawsuit as the catalyst for the investigation. I got a few calls from reporters, but I declined to comment. The criminal case moved through the system slowly. Patricia initially pleaded not guilty and hired an expensive defense attorney. But as the evidence mounted, her position became untenable. In March of the following year, she accepted a plea deal. She pleaded guilty to felony theft and agreed to pay full restitution to the HOA. She was sentenced to 2 years of probation, 6 months of home detention, and 300 hours of community service. She also had to permanently resign from any HOA board positions and was prohibited from serving in any fiduciary capacity. When I heard about the sentencing, I felt a complicated mix of emotions. Part of me felt vindicated. Patricia had abused her power and stolen from her neighbors, and she was being held accountable. But another part of me just felt sad about the whole situation. She'd thrown away her reputation, and potentially her freedom over relatively small amounts of money and petty power trips. Grace and I talked about it that evening, sitting on my back deck watching the sun set over the Rockies. "You regret fighting the fine?" she asked. "No," I said without hesitation. "If I hadn't, she'd still be doing it. Other people would be getting harassed and the embezzlement would have continued. It was the right thing to do. Even though it turned into this whole saga, especially because it turned into this saga. Sometimes you have to stand up to bullies, even when it's expensive and exhausting." She leaned her head on my shoulder. "I'm proud of you. I'm just glad it's over." But in a way, it wasn't really over. I ended up serving as HOA president for 2 full years before I'd built up enough goodwill and stability to hand the position over to someone else. During that time, we completely rewrote the enforcement procedures, implemented transparent budgeting, and established term limits for board members. We turned Ridgeview Heights from one of the more contentious HOAs in Boulder County into something approaching functional. The legal fees that Judge Brennan had awarded me ended up being paid by the HOA's insurance company after some back and forth. It took nearly a year, but eventually I received a check for the full amount, $6,400, plus interest. I used part of it to take Grace on a vacation to Hawaii and donated the rest to a legal aid organization that helps homeowners fight predatory HOAs. The snow removal fine that had started everything, the $350 that Patricia had insisted I owed, was formally voided by court order. I framed the judge's ruling and hung it in my home office as a reminder that sometimes standing up for what's right, even in small matters, can lead to bigger changes. Looking back now, almost 2 years after that February snowstorm, I can see how much my life changed because I refused to pay an unjust fine. I became more engaged in my community. I learned about HOA law and governance. I met neighbors I never would have known otherwise. Grace and I built a deeper relationship through the stress and uncertainty of the legal battle. And perhaps most importantly, I learned that institutional bullies, whether they are HOA boards or anyone else, often back down when someone actually challenges them. Patricia Winters completed her probation and community service without incident. She moved out of Ridgeview Heights about 6 months after her sentencing. I heard through the neighborhood gossip network that she relocated to Arizona to be near her daughter. I never spoke to her again after that courtroom hearing where Judge Brennan had dismantled her case. Dale, the former vice president who had enabled Patricia's worst impulses, also left the board. He apologized to me privately one day, explaining that he'd gone along with Patricia because she was so forceful and he didn't want the conflict. I accepted his apology, but told him that being conflict-averse isn't an excuse for letting someone abuse power. He seemed to take that to heart. The new board that eventually took over after my tenure was competent and reasonable. They continued the reforms we'd started and maintained the more collaborative approach to governance. Ridgeview Heights became the kind of neighborhood where people actually wanted to serve on the HOA board rather than seeing it as a burden or, worse, an opportunity to wield petty authority. As for me, I went back to my quiet life as a software developer. Grace and I got engaged that December, standing on the same back deck where we'd had so many conversations about the lawsuit and its aftermath. We planned a simple wedding for the following summer. The whole experience taught me several important lessons. First, HOA covenants are only as reasonable as the people interpreting them. Vague language can be weaponized by bad actors to justify almost anything. Second, most people will accept injustice if fighting it seems too expensive or time-consuming, which is exactly what bullies count on. Third, legal systems, for all their flaws, can actually work when you have the facts on your side and a judge willing to see through nonsense. But perhaps the most important lesson was about community. A neighborhood isn't just houses and streets and covenants. It's people trying to live their lives, and the structures that govern those communities should help rather than hinder that basic goal. When an HOA board forgets that and starts treating residents as subjects to be controlled rather than neighbors to be served, something has gone fundamentally wrong. I never imagined that hiring a snowplow would lead to a court victory, an HOA presidency, a criminal investigation, and ultimately a better neighborhood. But that's exactly what happened, all because I decided that sometimes $350 isn't really about the money at all. It's about drawing a line and saying no when someone tries to abuse whatever small amount of power they've been given. The framed court order still hangs in my office. Every time I look at it, I remember Judge Brennan's words. The plaintiff's case is without merit, judgment for the defendant. 6 words that validated months of stress and thousands of dollars in legal fees. 6 words that said I was right to fight back. Grace sometimes jokes that I'm the only person she knows who can turn shoveling a driveway into a federal case. She's not wrong, though technically it was only small claims court. But her point stands. I could have just paid the fine and moved on. Plenty of people told me I should. It would have been easier, cheaper, and less stressful, but I didn't, and I'm glad I didn't. Because Patricia would have kept going, and other people would have suffered, and eventually the embezzlement would have grown to the point where it seriously harmed the community's finances. By standing up for myself over something relatively small, I inadvertently stood up for everyone. That's not to say I'm some kind of hero. I was just a guy who got angry about an unfair fine and had the resources to fight it. Plenty of people aren't that lucky. They can't afford lawyers or don't have the time to attend board meetings or lack the social capital to rally neighbors to their cause. The system still favors those with resources, and that's a problem that extends far beyond HOA disputes. But within the small sphere of Ridgeview Heights, we managed to make things better. We turned a dysfunctional, adversarial HOA into something more reasonable and humane. We held a corrupt board president accountable. We recovered stolen money and implemented safeguards to prevent it from happening again. Those aren't world-changing accomplishments, but they mattered to the 200 families who lived in our neighborhood. The restitution Patricia paid back was used to fund several deferred maintenance projects and to reduce HOA dues for 2 consecutive years. Every homeowner got a small refund as a result of recovering the embezzled funds. It was a tangible reminder that fighting back against corruption, even at the local level, can produce real benefits. I also learned more than I ever wanted to know about Colorado HOA law. I became something of an informal resource for other homeowners in the area dealing with their own HOA problems. I'd get calls or emails from people I barely knew asking for advice about violation notices or board disputes. I tried to help when I could, usually by pointing them toward resources or recommending Jennifer's law firm. Jennifer and I stayed in touch professionally. She told me that my case had opened doors for her practice. Other homeowners who heard about the outcome reached out to her firm, and she built a thriving niche practice representing people in HOA disputes. She said I was her favorite client because the case was so clear-cut and the judge's ruling was so decisive. It gave her great case law to cite in future matters. The local media did eventually do a longer feature story about the whole saga, about a year after Patricia's sentencing. A reporter from the Boulder Daily Camera interviewed me, several neighbors, and even spoke with Judge Brennan off the record. The article was titled, "How a Snowplow Bill Uncovered HOA Corruption," and it got picked up by a few national outlets that cover HOA issues. For a few weeks, I got emails from people around the country sharing their own HOA nightmare stories. The common theme was feeling powerless against boards that operated with minimal oversight and maximum arrogance. Some of the stories made my situation look tame by comparison. People being foreclosed on for minor violations, subjected to daily harassment, or financially ruined by escalating fines. It reinforced my belief that HOAs, while potentially useful for maintaining common areas and organizing community resources, have a dangerous tendency to attract people who crave petty power. The lack of real accountability and the broad authority granted by covenants create opportunities for abuse. Reform is needed at the state level to give homeowners more protection and to impose stricter standards on HOA governance. I even testified before a Colorado legislative committee that was considering HOA reform legislation. I told my story and advocated for stronger homeowner protections, mandatory financial audits, and easier paths for removing board members who abuse their authority. Some of those reforms were eventually incorporated into a bill that passed the following year. It wasn't perfect, but it was progress. Through all of this, Grace remained my anchor. She celebrated the victories and comforted me through the frustrations. When I got too focused on HOA politics, she'd remind me to step back and remember what actually mattered. When I felt overwhelmed by the responsibility of fixing the neighborhood's governance, she'd help me prioritize and delegate. Our wedding took place in June at a small venue in the mountains outside Boulder. We kept it simple and intimate, just close friends and family. Several of my neighbors attended, people who had become genuine friends through the shared experience of reforming the HOA. Dale even came, which surprised me but felt right somehow. Everyone deserves a chance at redemption. As I stood there watching Grace walk down the aisle, I reflected on how much had changed since that snowy February morning when I'd called a plow service. The decision to fight a $350 fine had altered the trajectory of my life in ways I never could have anticipated. It had revealed corruption, sparked reform, built community, and somehow led me to become more deeply rooted in a place I'd once viewed as just a house in a subdivision. The final chapter of the legal saga came about 18 months after the initial court hearing. The HOA's insurance company, which had paid my attorney fees under the court order, filed a subrogation claim against Patricia personally to recover those costs. They also went after her for the costs they'd incurred defending the original lawsuit. Between the criminal restitution and the civil liability, Patricia ended up owing close to $90,000. I heard she declared bankruptcy. Part of me felt bad about that, but mostly I felt that actions have consequences. She'd made choices, bad choices motivated by ego and greed, and now she was paying the price. Maybe it would serve as a warning to other wannabe HOA tyrants that abusing your position can cost you dearly. The bankruptcy meant that some of the money owed to the insurance company would never be recovered, but that wasn't my problem. I'd gotten my legal fees paid. The HOA had been reimbursed for the embezzled funds through Patricia's restitution payments, and the neighborhood was in far better shape than when this all started. That was enough. As Grace and I settled into married life, the story of the snowplow fine became a kind of legend in Ridgeview Heights. New residents would hear about it and ask me if it was really true. I'd give them the abbreviated version, always emphasizing that I hadn't set out to be some kind of crusader. I'd just been trying to stand up for myself, and things had escalated from there. The story also became a teaching moment for the neighborhood about the importance of staying engaged with HOA governance. Attendance at board meetings remained high years after the scandal. People paid attention to the budget and asked questions about expenditures. Elections were contested with multiple candidates offering different visions for the community. It was democracy at its most local and, arguably, most important level. I eventually rotated off the board entirely and declined to run for re-election. I'd done my part, and it was time for others to step up. The woman who replaced me as president was a retired city planner who brought professional expertise to the role. Under her leadership, the HOA became even more efficient and responsive. It was gratifying to see that the reforms we'd implemented had staying power. Life returned to its regular rhythm. I worked on my software projects, Grace taught her students, and we built our life together. We adopted a dog, a rescue mutt named Cooper who loved to play in the snow. Every winter when the first big storm came through, I'd watch Cooper bounding through the drifts in our backyard and remember how much trouble a simple snowstorm had caused. But I'd do it all again. Not because I enjoyed the stress or the conflict, but because sometimes standing up for what's right, even in small matters, is what separates functioning communities from dysfunctional ones. Patricia had counted on my apathy, on the assumption that I'd just pay the fine rather than fight it. She'd been wrong about that, and her miscalculation had exposed years of mismanagement and fraud. The plowing bill that Patricia had sent me, the one demanding $350 for the crime of maintaining my own property, ended up costing her everything. Her reputation, her freedom, her finances, all sacrificed on the altar of petty tyranny. Meanwhile, I'd gotten my legal fees paid, helped reform an entire HOA, and learned valuable lessons about community and civic engagement. Judge Brennan, in throwing out the HOA's case and ordering them to pay my legal fees, had done more than resolve a dispute. He'd sent a message that HOA boards are not above the law, that homeowners have rights, and that abusing authority has consequences. That message rippled out beyond just my case to influence how other boards operated and how other homeowners viewed their rights. As I write this, nearly 3 years after that snowstorm, Ridgeview Heights is thriving. Property values have increased partly due to the perception that the neighborhood is well managed and homeowner-friendly. People actually want to serve on the board now because it's seen as genuine community service rather than a thankless job or a power trip. The clubhouse that Patricia had wanted to renovate at great expense ended up being updated for a fraction of the cost through a combination of volunteer labor and smart contractor negotiations. The lawsuit and its aftermath became part of my identity in ways I'm still processing. I'm known in the neighborhood as the guy who stood up to the HOA, who exposed corruption, who made things better. It's a reputation I'm proud of but also slightly uncomfortable with. I didn't do it alone. Jennifer deserves credit for her legal expertise. Grace deserves credit for her support. The other homeowners who voted Patricia out and supported reform deserve credit for their civic engagement. But I was the catalyst, the person who refused to accept an injustice, even when accepting it would have been easier. That choice, made in anger and principle, ended up mattering more than I ever imagined it could. It's a reminder that individual actions, even small ones, can have outsized impacts when they challenge systems that rely on compliance and apathy. The $350 fine became $6,400 in attorney fees paid by the HOA. It became $23,000 in embezzled funds recovered. It became reforms that protected 200 families from future abuse. It became criminal charges and accountability for corruption. The return on investment, both moral and practical, was extraordinary. And it all started because I hired a snowplow service during a February storm and refused to be punished for it. That's the power of standing your ground, of saying no to unreasonable authority, of believing that justice matters even in small disputes. Judge Brennan threw out their case and made them pay my legal fees, but the real victory was everything that came after. The reform, the accountability, the community building, the proof that fighting back against institutional bullying can actually work. So that's my story. It's the story of how a plowing bill turned into a 2-year saga of lawsuits, elections, investigations, and ultimately meaningful change. It's specific to Ridgeview Heights and Boulder County and Colorado HOA law, but the lessons are universal. Don't let petty tyrants get away with abusing their power. Stand up for your rights even when it's expensive and exhausting. Get involved in the institutions that govern your daily life. Hold leaders accountable. Build community around shared values rather than fear of violations. These aren't revolutionary ideas, but they're easily forgotten in the grind of daily life. Sometimes it takes something as absurd as being fined for plowing your driveway to remind you that civic engagement matters, and that regular people can make a difference when they refuse to accept injustice. Patricia Winters learned that lesson the hard way. I learned it too, though my education was far less painful than hers. And 200 families in Ridgeview Heights benefited from both of our educations, living in a better governed community because one person decided to fight an unfair fine and everything that came tumbling out as a result. As Grace and I look toward the future, planning for kids and thinking about putting down even deeper roots in Colorado, I'm grateful for how things turned out. The house I bought as just a place to live became the center of a story about justice and community. The neighborhood I barely paid attention to became a place where I have genuine connections and friendships. The HOA I resented became an organization I helped transform into something functional and fair. All because I refused to pay for plowing my own driveway. All because a judge saw through Patricia's nonsense and threw out her case. All because Colorado law allowed me to recover my attorney fees and made fighting back financially viable. All because enough was enough, and someone had to say it out loud in a courtroom where it mattered. That's the end of the story, or at least the end of this chapter. Life continues, seasons change, and Colorado keeps getting big snowstorms every winter. But now, when I need my driveway plowed, I hire whoever I want without a second thought, secure in the knowledge that no HOA will ever again try to fine me for maintaining my own property. And if they do, well, I know exactly what to do about it.